tribes. Let me just give you highlights of yesterday's hearing. It was not that extensive, but we sure did get a lot also from what we covered yesterday. First among the resource persons called was Secretary Vitaliano Aguirre, who was requested to clarify questions on the alleged delay in the transfer of the Maute cases. The authorized representative from the BIR also appeared before the committee to give an update on the subpoenaed documents by the committee. Although they have issued the necessary notices to gather information on the matter, the Bureau has yet to finalize and submit process papers required by the committee. They requested for an extension to give time to gather the required documents. The committee then proceeded with a discussion on the allegations under corruption, particularly on the use of public funds in her extravagant travels or alleged extravagant travels and stay in opulent hotels. Also yesterday, of course, the Supreme Court Public Information Office issued a media briefer stating that the court and bank allowed Supreme Court justices, officials, and employees to appear before this committee. Later, I will ask the COMSEC to read into the records at the very least, since there is no resolution promulgated as yet, the media briefer that was given to the media yesterday by Attorney Teodorte, so that this, in the hope that this will all guide the members of the committee, and for the public to know also the extent of testimonies that will be given to us by the members of the Supreme Court or their officers or its officers. Today we continue with the presentation of witnesses on the allegations of culpable violation of the Constitution and corruption to determine whether there is probable cause that an impeachable ground or grounds exist. And for today, we invited the following resource persons, and we thank, of course, first and foremost, the Honorable Justice Teresita Leonardo-De Castro, who will testify on the allegations involving the creation of the Regional Court Administrative Office in Arcao in Region 7, the Temporary Restraining Order or TRO of the Supreme Court in the case of Senior Citizens Party List versus COMELEC in GR number 206844-85, on the several allegations pertaining to the manipulation of the Judicial and Bar Council and the unilateral issuance of the resolution of the Supreme Court in Administrative Matter number 16-08-04-SC, which supposedly directed the Executive Secretary to submit complaint affidavits against 4 judges allegedly involved in illegal drugs. We also invited Honorable Retired Justice Art Brion, who wrote to inform us that he cannot attend today's hearing because, and I would like to read into the records his email, "I regret that I am too sick to come today for your hearing. I shall come as soon as I am able. I ask Mr. Midas Marquez to submit to you my written opinions on the Hardelesa versus Sereno case. They can at least serve as additional guides when Justice De Castro testifies." Likewise, we invited Honorable Justice Francis Hardelesa, who I understand cannot also appear today, but committed to appear in the succeeding hearings upon invitation of this committee. but he will testify on the circumstances surrounding his petition in the case of Hardelesa versus Sereno with GR number 213181 dated August 19, 2014. We also invited, and we'd like to thank Court Administrator Midas Marquez, who is here today, who will testify on the overall administration of the Supreme Court, the allegation involving the creation of the Regional Court Administrative Office in Region 7, and on the delay in the retirement benefits of judges and justices. We also invited Attorney Leonardo-De, Chief of Public Information Office of the Supreme Court, and Attorney Felipa B. Anama, but they requested that their attendance be held in abeyance until the official issuance of a resolution by the, or probably the promulgation of the resolution by the Supreme Court. So for today, the flow of the meeting, and for an orderly proceeding, we will start with the presentation of the resource person with a testimony or affidavit prepared by each invited person, if there is any. And I'd like to ask the Honorable Justice De Castro if you have a prepared affidavit or opening remark.
I did not prepare any affidavit, but I will be ready to answer the questions propounded by the Honorable Committee members, Chair and Vice
What
Chair.
about an opening remarks, ma'am? Do you have prepared one?
Yes, I can. Just a very brief opening remarks. I'd like to inform the body that when I received the invitation of the Honorable Chairman of this committee last Friday, so by Monday, I made sure that there will be a request that this be placed in the agenda of the Court and Bank, which meets every Tuesday. So, true enough, the invitation was calendared and for the en banc session on Tuesday, and we were able to deliberate on it. I was present during the deliberation. We have not yet issued the formal resolution, but I am very well aware of the limits of what I can testify on before this honorable committee. Now,
Thank you, Madam Justice. I'm just asking if you have a prepared speech. I will also ask Attorney Midas Marquez if he has a prepared remarks or affidavit, because you are also called in as one of the resource persons.
I just want to add something more, just a brief
Thank you, Madam.
statement.
Please continue.
I welcome this opportunity because this will be the right time for me to explain to everyone the process that we follow in deciding cases in the Supreme Court. And I also believe that this is the proper venue where I can correct the misinformation that has been spread many times during this period.
Thank you, Madam. We will go into that later. What about you, Attorney Marquez? Did you have, because we are just defining the flow of the hearing. So if you have a prepared one, please submit it, and then we will ask you later to read it into the records, and then if you have, no. Pero if none, then we will just proceed with the hearing and some clarificatory questions from the members.
Thank you, Your Honor. Good morning, Your Honors. Unfortunately, I did not prepare any prepared or affidavit. I did not execute, but just like Justice De Castro, I'm willing to answer all questions propounded by the committee members.
Thank you. Thank you for that. So anyway, again, I enjoin everyone to stick to the factual issues, no, and do not dwell on conclusions of law or questions on personal belief, because this is not what we need for purposes of completing our task particularly in the crafting of the articles of impeachment, if we will ever come to that and vote on probable cause to impeach the Chief Justice. Let us take and maximize this opportunity that we have with us, Associate Justice De Castro and Attorney Maidas Marquez. We will have other witnesses. They do not have all the complete facts, and I'm sure there will be other witnesses who can testify on some other matters. But for us to be able to really complete our task, what we need really are the factual recitals that we will have to rely on for purposes of making our decision. So again, before I end, I would like to thank, of course, the Supreme Court for voting unanimously to allow us to perform our constitutional mandate of exacting accountability on the highest public officials of the land. This is the only purpose of this impeachment committee, and this is a power vested no less by the Constitution that we are performing, and we enjoin that everyone give this committee that respect that it needs, in like manner that I enjoin the members to give our resource persons who are our co-equals in another department, which is judiciary, the respect that they deserve as resource persons of this committee. Magandang umaga po. Maraming salamat po. So now I'd like to ask the COMSEC to please acknowledge acknowledge the members and guests present in today's hearing.
Good morning, Your Honor. The committee acknowledges the presence of the following members of the committee. We have the Honorable Majority Leader Rodolfo Fariñas, Senior Deputy Majority Leader Honorable Juan Pablo Bondoc, the Honorable Senior Vice Chairperson Vicente Veloso, Vice Chairpersons Honorable Dorly Atchon and Henry Womenal. We have Honorable Deputy Speaker Gwendolyn Garcia and the Honorable Representatives Roel Peter Gonzaga, Eugene Michael De Vera, Alfred Garbin, Roger Mercado, Anthony Bravo, Mark Go, and Jerry Treñas. We also have Representatives Kit Belmonte, Ramon Rocamora, and the Honorable Edsel Lagman. For the resource persons, we have the complainant, Attorney Larry Gadon, and we also have the Honorable Justice Teresita Leonardo-De Castro and the Honorable Court Administrator Maidas Marquez from the Supreme Court.
And the complainant? And now may I request the COMSEC to read into the records at least the media briefer of the Supreme Court in the resolution of the issue of attendance of members of the Supreme Court and or officers in the hearing, in this impeachment hearing.
Republic of the Philippines Supreme Court, Public Information Office, Media Briefer, November 28, 2017. The Supreme Court en banc, during its session today, acted on the following matter indicated below. Number 1, in the matter of the invitations of the Committee on Justice, House of Representatives, addressed to the Associate Justices and other Supreme Court officials to appear and testify before the committee regarding the allegations in the impeachment complaint filed against the Chief Justice, the Court resolved as follows. A, as far as the invitation is for testimony on administrative matters, any official of the Supreme Court who is invited may appear and give testimony if he or she so wishes. B, as far as the invitation is for testimony on adjudication, only Associate Justice Teresita J. Leonardo-De Castro is authorized to testify and only on the following matters. A, in relation to GR number 206-844-245, Coalition of Association of Senior Citizens in the Philippines Party List versus Commission on Elections, only on the issuance of the TRO in these consolidated cases and the exchange of communications between herself and the Chief Justice. but not on the deliberations of the court that led to the issuance thereof. B. In relation to GR number 224302, Honorable Philip Aguinaldo et al. Versus President Benigno S. Aquino III, only on the merits of her ponencia, but not on the deliberations of the court in this case. And C. In relation to GR number 213181, Francis H. Hidalesa versus Chief Justice Maria Lourdes P.A. Sereno et al., only on the merits of her separate concurring opinion, but not on the deliberations of the court in this case.
Okay, so since our resource persons do not have prepared opening remarks and or affidavits, perhaps before we proceed, we would ask them to, and I direct the COMSEC to please administer the oath for the two resource persons. Please stand up, Justice. And Attorney Marquez, please.
Please raise your right hand, state your name for the record.
I am Justice Teresita Leonardo-De Castro.
I am Jose Maidas Marquez.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, I do.
Thank you. You may take your seat.
Yes, I do.
Thank you. You may take your seat.
So, if you want to add to what you said earlier, Madam Justice, we will now give you the floor.
I'm ready to answer
Yes,
questions
answer.
from the committee, but I wish to ask permission to refer to my documents in the course of my testimony. Because, you know, the incidents involved in this proceeding happened many years ago. The earliest was in 2012. And at that time, it was beyond anyone's imagination that this hearing will come about. So I would like to seek that permission
Please,
to refresh my memory in the course of my testimony.
please, you may use all your references to be able to refresh your memory. And likewise, Attorney Marquez. So the table is now open for clarificatory questions. You have a copy of the complaint, the answer, the reply, and the rejoinder of the parties in this case. And you have the copies of the administrative matters that are related to those matters that our resource persons will testify on. So I guess we will be ready on these matters. And so we would like, again, may I ask everyone, for those who would like to ask clarificatory questions from our resource persons, please register your name with the COMSEC. And we now recognize the Honorable Majority Leader Fariñas for the initial clarificatory questions.
Thank you, Mr. Chair. Good morning, Your Honors. Good morning, Madam Justice.
Good morning.
Justice Marquez, good morning po.
Morning.
First of all, ma'am, on behalf of the Speaker and the House of Representatives, I wish to thank you for accepting our invitation, for honoring our invitation, and kindly relay to the Supreme Court the appreciation of the House for upholding the power and duty of the House in impeachment proceedings. Maraming salamat po, ma'am. This is unprecedented, I think, that a member of the Supreme Court will appear and has been authorized by no less than the Supreme Court to appear before the House of Representatives. Ma'am, you are a very intelligent person, being a justice of the Supreme Court. We will not be asking you questions, but kindly educate us and inform us about the matter regarding the issues involved here. First, I'll concentrate on the alleged illegal creation of the Regional Court Administration Office Number 7. And We have in our possession, ma'am, a letter containing 3 pages purportedly coming from the chambers of Teresita J. Leonardo-De Castro, Associate Justice. It's dated December 3, 2012. May I ask the page to kindly give a copy to Justice Castro for her to identify this one. This is an exact copy of what I have. Tingnan ko lang, baka naman okay ba? Yun. Kindly show the good justice. There's a signature, ma'am, on the last page, which legibly shows Teresita Leonardo-De Castro.
Yes, this is my signature.
And this was your letter, ma'am?
Yes, this is my letter.
It is a memorandum, I'll read into the records, memorandum for Chief Justice Maria Lourdes P.A. Sereno and the Associate Justices from Justice Teresita J. Leonardo-De Castro, recall amendment of the resolution dated November 27, 2012, issued by the Chief Justice in order to conform to the deliberation of the Court en banc on the said date in administrative matter number 12-11-9-SC, and it's dated December 3, 2012. This is very relevant to our proceedings, ma'am, because one of the allegations of the complaint is that on paragraph 4.1.1, it states here that Respondent Sereno, and 4.1, committed a culpable violation of the Constitution when she falsified the resolution of the Supreme Court in AM-number 12-11-9-SC. And in the succeeding paragraph, it states, ma'am, upon her assumption to office as Chief Justice, Respondent Sereno unilaterally issued Administrative Order number 175-2012, open parenthesis, designating the head for the Judiciary Decentralized Office, another bracket, JDO, close bracket, in the 7th Judicial Region, close parenthesis, dated November 9, 2012, reviving the Regional Court Administration Office in Region 7, which the term JDO 7 without the knowledge of the Court en banc. And then the next paragraph, Attorney Gadon alleges that to ratify her unilateral act, she made it appear that the Supreme Court en banc subsequently issued a resolution approving the revival of the Arcao 7, a project that was supported and funded by the Asian Development Bank, but scrapped by the Supreme Court following a failed pilot testing in 2008. The resolution, which was supposedly issued on November 27, 2012, in AM number 12-11-9-SC, reopening the Regional Court Administrative Office in Region 7 Ridge. This purported resolution contains the following matters. Open parenthesis, open quotation marks rather. The court resolved to A, ratify the action of the Chief Justice Maria Lourdes P.A. Sereno to revive the Arcao in Region 7 with Phase 1 on A, procurement, B, approval of leave, C, payroll administration, and letter B, appoint Judge Geraldine Faith A. Ekong, Deputy Clerk of Court and Judicial Reform Program Administrator, as officer in charge of Arcao 7. So it states here, ma'am, that you wrote a letter on December 3, which you have affirmed, Supreme Court Associate Justice Teresita Leonardo-De Castro called the attention of Respondent Sereno through a memorandum which was concurred in by several justices, stating that it was not true that the Court en banc ratified Respondent Sereno's act of reviving the Arcao 7. Justice De Castro manifested that the true consensus of the Court en banc did not appear in the November 27 resolution, which was to oppose the reopening of Arcao 7. And then in the next paragraph, it states that in her in that same memorandum, Justice De Castro said that Respondent Sereno was depriving the High Court. Anyway, ma'am, like I said, can you kindly explain to us and maybe read into the records and then explain the contents of your memorandum to the Chief Justice?
Before I do that, may I ask a permission from the Honorable Chair and Vice Chair to allow me to explain the background of the Regional Court Administration Office?
Please, please do,
Please,
Madam.
This issue about ARCAW started when on November 23, 2012, the justices, the associate justices of the court received an invitation coming from the Office of the Chief Justice, inviting us to attend the reopening of the Regional Court Administration Office in Region 7 on November 29. This was an invitation sent to us by the PS of the Chief of Staff of the Chief Justice. I was taken aback because we are invited only to a launching of the Regional Court Administration Office in Region 7, and we were not at all consulted and made to participate in this decision to reopen the Regional Court Administration Office. So this prompted me to look deeply into the matter, and I found out that the Chief Justice issued Administrative Order number 175-2012, designating the head for the Judiciary Decentralization Office in the 7th Judicial Region. Even the heading of this administrative order shows that this is not meant to implement the ARCAW as approved by the Court and Bank unanimously. I'd like to show to you the resolutions of the Court and Bank, which was also cited in the administrative order issued by Chief Justice Sereno. And if you will look at before that, the administrative order referred to AM number 0611-09 SC, and this was adopted on November 14, 2006, unanimously by all the justices of the Supreme Court. The resolution, if you will look at this copy that I brought here, bear the signature of all the justices that approved the resolution. And there is also another one, also mentioned by the Chief Justice, the resolution in AM number 06-1206 SC, pertaining also to the establishment of the Pilot Regional Court Administration Office. And this copy would show that this was again unanimously approved by all the justices of the court, with only one not able to sign it because she was on official leave. So both of these documents are en banc resolutions, which, according to the Chief Justice, she would like to implement. But when I compared the administrative order issued by the Chief Justice, it did not conform to the provisions of this administrative matter adopted by the Court and Bank. If I may be allowed to show to you a matrix that I prepared comparing the two, is it?
Do you,
Please, ma'am, do you have a...
Yes, I have I have a PowerPoint
Yeah.
presentation.
please,
Yeah, thank you, ma'am.
tayong ilaw
This
dito.
is I made it very brief. I just pointed out the most significant provisions in this administrative matter adopted by the Court and Bank, which is on the left side, and Administrative Order number 175/2012 issued by the Chief Justice. So the M-Bank resolution created the Regional Court Administration Office in the 7th Judicial Region. The administrative order created the Judiciary Decentralized Office, or JDO, for the 7th Judicial Region. It shows a deliberate act of not referring to the Regional Court Administration Office, which would place this office under the office of the Court Administrator. So if it is a decentralized Judiciary Decentralized Office without any reference at all to the Court Administration Office, then this will be independent of the office of the Court Administrator, and this will be contrary to law because it is the office of the Court Administrator that assists the court in the administrative supervision of all courts.
Yes, ma'am. May I just give some insights? Because the creation of an office, creation of public office, is it legislative, judicial, or executive in nature, ma'am?
I also mentioned that in my
Yes,
memorandum.
ma'am. I'm just asking for
Yes.
our record.
The Chief Justice cannot create an office.
Because
Not-
that power belongs to the
Yes,
legislature.
it is a legislative power.
Yes, ma'am. Not even the
Because-
Supreme Court can create an
Yes,
office.
yes.
Yes, ma'am.
So what she did is it appears that she created a permanent office. The RCOW is not a permanent office. So even if it was created by the court, it is a pilot project. So it is an ad hoc body. So it has no permanency. So it will not come within the exclusive legislative power vested upon
Because not
Congress.
even the Supreme Court could create the office of the court administrator. Is that correct,
yes,
ma'am?
yes.
It was created by law.
No, the office of the court administrator, yes, was created by OCA, and it precisely provides that it is the OCA which will assist the court in the exercise of its power of administrative
Yes, ma'am.
supervision.
You're referring to Presidential Decree 828,
Yes, as amended.
creating the office of the court administrator. In fact, ma'am, in that very same law, it states in Section 7 that the Supreme Court shall create such offices, services, divisions, and other units in the offices of the court administrator as may be deemed necessary, and for this purpose, the Chief Justice is authorized to adopt and implement the corresponding staffing patterns approved by the Supreme Court.
Yes, it is.
That's
always-
why the Supreme Court can only create these offices because the law, Congress has delegated that power to Congress, and the Supreme Court, and the Supreme Court should adhere to the provisions of the law.
Yes, Your Honor.
Thank you, ma'am.
That is a valid exception to the prohibition against creating an office. If there is a
As long as there are details
there is
that will
valid
guide the
delegation.
delegate. Yes, ma'am.
And aside from that, Your Honor, since the RCOW is only a pilot project, it is explicitly, these resolutions of the Supreme Court provides that it is only for a one-year period. It's a pilot. They're just testing how wise it is to come up with a decentralized office like the RCOW. So,
Proceed, ma'am.
So, the other item that provision that departs from the resolutions of the court is that, as I mentioned, the RCOW is a pilot decentralized unit implemented over a one-year period. But the administrative order issued by the Chief Justice says that it is effective immediately until revoked by the Chief Justice. So there is some kind of permanency, and it is up to the Chief Justice to decide until when this JDO will exist. Now, the other item is that the court administrator under court resolution is the implementation head of the pilot project. Now, in the administrative order of the Chief Justice, the Judiciary Centralized Office Head, designated by the Chief Justice, who was at that time it was the Program Management Office Head, and not an official of the Office of the Court Administrator. So this again would show that there's no connection between this Judiciary Decentralized Office created by the Chief Justice and the Office of the Court Administrator. Now, the resolutions of the court, the other item is that the official functions in the pilot RCOW are vested in the following: the court administrator, the regional court administrator, the deputy regional court administrator, the Assistant Regional Court Administrator, and there is an oversight committee. Now, in the administrative order of the chief, the official functions are all vested in the head of the JDO. It made reference to the resolution of the court, only stating that the JDO head will perform all the official functions mentioned in the resolution of the court. Now, and the last item that I would like to note is that under the court resolution, the staffing pattern must be court approved, and the designation of ARCAO personnel shall be approved by the Chief Justice upon recommendation of the court administrator. But Administrative Order Number 175, thus 2012, states that the hiring of contractual personnel for the JDO for the 7th Judicial Region must be consistent with the staffing pattern approved by the Chief Justice. So because of this analysis, I decided to write the court and bank, and before the letter that you read into the records, I have there was an earlier memorandum which I sent to the other justices.
May we have a copy of that, ma'am? You only have one copy, ma'am?
I have it here. Now,
okay, ma'am. We will copy it later. We'll reproduce
this
it.
is dated, saan ba yung date? You can see the date. It's November 26. Because I received the letter on November 20, the invitation on November 23. So I wrote a letter on November 26 and asked that it be placed in the agenda of the court and bank.
Is it lengthy, ma'am?
It's quite lengthy in the sense that maybe I can omit the grounds that I mentioned why I am opposing.
Can you read the relevant portions, ma'am,
yes,
to our inquiry?
May I explain why I am the one who took the initiative to bring this up? During the incumbency of Chief Justice Renato Puno, I was appointed member of the Management Committee on Judicial Reform Support Project, and that is the committee that oversees the judicial reform projects of the court. Now, when the senior justices retired and Chief Justice Renato Corona assumed his position, I was promoted to chairman of the Management Committee that I mentioned. And this management committee oversees all the judicial reform projects, including the establishment of the pilot ARCAO. So among the justices at the time when this was reopened, I am the one most familiar with the circumstances surrounding the establishment of the ARCAO.
How long have you been in the Supreme Court, ma'am?
I've been there since 2007. So I'm now...
So almost 10 years that you have been a member of the Supreme Court.
Yes, almost 10 years.
And before that, ma'am?
Before that, I was 10 years I served as First Associate Justice of the Sandigan Bayan and then Presiding Justice of the Sandigan Bayan. And before that, I spent 19 years of my government service at the Department of Justice. And before that, I worked in the Supreme Court as a young lawyer for 5 years.
Yes, I remembered appearing before you in the Sandigan Bayan.
Yes, so I now have a total.
I was acquitted.
Yes.
Thank you, ma'am, for the acquittal.
Yes, he was acquitted. So I'm now in my 44th year in government service.
Establishing, para po malaman ng publiko kung gaano po ka-extensive yung background ni Justice De Castro sa batas at sa judikatura. Please proceed, ma'am.
So, because of that position in Mancom, I was the one very much interested in looking into the matter of the reopening of the ARCAO. Because I know even then that there were a lot of problems encountered in the reopening of the ARCAO. It was the resolution that I mentioned, which provided for the establishment of this pilot ARCAO, was issued in 2006. And so, at the time that Chief Justice Sereno reopened this, well, she said she's reopening it, but she's setting up a different organizational setup in decentralizing region